Good day, everyone. Today we will discuss Business Law, Module 14, Reformation of Instruments and Interpretation of Contracts, presented by Group 2 under the guidance of Sir Gary. Interpretation and reformation is a fix-it problem tool for contracts and documents when the accuracy of the parties' agreement doesn't reflect. The distinction between the two relies between the correction and clarification of the contract. Reformation focuses on correction of the document. It's about meeting the mind of both parties where they actually agreed on something. However, the written document, say, fails to accurately meet the true agreement. It usually happens when one party made a mistake on the contract or it was written by accident. Basically, reformation only corrects the contract so it matches the original agreement. Interpretation is a process of figuring out the words written on the document when it has multiple meaning and it's open for an interpretation. It's an analyzation of the context of the words to figure out what it actually means. In short, interpretation is about the clarification of the words in the document. Basis of reformation, contract proferentum, mutual mistake. Mutual mistake is mistake of fact that is common to both parties of the instrument, which causes the failure of the instrument to express their true intention. When a mutual mistake of the parties causes the failure of the instrument to disclose their real agreement, said instrument may be reformed. However, when the mutual error of the parties relates to the legal effect of their agreement, which frustrates the real purpose of the contract, the consent is vitiated, and the remedy is not reformation, but annulment of the contract. Other cases when reformation is allowed. Article 1362. If one party was mistaken and the other acted fraudulently or inequitably in such a way that the instrument does not show their true intention, the former may ask for the reformation of the instrument. Article 1363. When one party was mistaken and the other knew or believed that the instrument did not state their real agreement, but concealed that fact from the former, the instrument may be reformed. Article 1364. When through the ignorance, lack of skill, negligence, or bad faith on the part of the person drafting the instrument or of the clerk or typist, the instrument does not express the true intention of the parties, the courts may order that the instrument be reformed. Article 1365. If two parties agree upon the mortgage or pledge of real or personal property, but the instrument states that the property is sold absolutely or with a right of repurchase, reformation of the instrument is proper. Statute of Frauds Interpretation Contract. The Statute of Frauds is a legal rule that requires certain types of contracts to be in writing and signed in order to be enforceable in court. Its main purpose is to prevent fraud, misunderstandings, and false claims about agreements. This rule does not make oral contracts illegal. Instead, it limits the ability of courts to enforce specific agreements unless there is written proof. Purpose of the Statute of Frauds. The Statute of Frauds serves two important purposes. 1. Evidentiary purpose. A written document provides proof that a contract exists and shows the agreed terms. 2. Cautionary purpose. Requiring written form makes parties think carefully before entering serious agreements. Contracts covered by the Statute of Frauds. The following types of contracts must generally be in writing. 1. Contracts in consideration of marriage. Example, a prenuptial agreement. 2. Contracts that cannot be performed within 1 year. If the agreement cannot possibly be completed within 1 year from the date it was made, it must be written. 3. Contracts involving the sale or transfer of land. Real estate transactions must be in writing. 4. Promises by an executor or administrator to pay estate debts from personal funds. 5. Contracts for the sale of goods worth $500 or more. Under the Uniform Commercial Code, UCC, in the United States, these must be in writing. 6. Suretyship agreements. A promise to pay the debt of another person must be written. Requirements of a valid written contract. To satisfy the statute of frauds, the written agreement must show that a contract exists, contain the essential terms, be signed by the party against whom enforcement is sought. The writing does not need to be a formal contract. It can be a memorandum, letter, or email, as long as it clearly shows the agreement. What happens if the contract is not in writing? If a contract falls under the statute of frauds but is not in writing, the court may refuse to enforce it. This means a person may not be able to legally force the other party to follow the agreement. Exceptions. There are situations where an oral contract may still be enforced. 1. Partial performance. If one party has already fulfilled part of the agreement. 2. Specially manufactured goods. If goods were made specifically for a buyer and cannot be resold. 3. Merchant confirmation rule. Between merchants, a written confirmation may be sufficient if not objected to within a reasonable time. Proferentum reformation. It means that if a contract is unclear or contains ambiguous terms, especially because of how it was drafted, the interpretation or correction of that contract will be made against the party who drafted it. In simple terms, if you wrote the contract and something in it is confusing, the law will interpret the confusion against you. The mutual mistake principle of effectiveness means that when both of the parties to a contract are mistaken about the same important fact, the law will try to preserve the agreement instead of automatically canceling it. The mistake must refer to the material fact that affects the true intention of the parties. Under this principle, the court focuses on what the parties really intended when they entered into the contract. If the written document does not express their real agreement because of the mutual mistake, the proper remedy is reformation. This principle is connected to the rule that the contracts should be interpreted in a way that makes them valid and effective rather than void. According to the Civil Code of the Philippines, particularly Article 1361, the reformation is allowed when a mutual mistake prevents the instrument from expressing the true intention of the parties. The goal is to correct the error and uphold the real agreement. In this way, the fairness and justice are protected, and the contract remains enforceable. That's all for today, everyone. We hope you learned something valuable from our discussion about business law, Module 14, reformation of instruments, and interpretation of contracts. Once again, this is Group 2. Thank you so much for watching and for giving us your time and attention.